Hello and welcome to the Herrington Carmichael Employment Law Update for November 2019. My name is Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and this month I've only got three things to talk to you about as there was less going on in the world of employment law, probably because we have a general election planned for December. So I'm going to bring you three cases, and I'm going to start with the case of Shanks and Unilever. Shanks and Unilever is about the benefit that is paid to employees where they create something, they create a patentable thing that is of real beneficial value to the employer. In the Patents Act there is an ability for an employee to pursue a claim in relation to what is this exceptional benefit, and in this case Mr. Shanks pursued that against Unilever because of an invention that he made in relation to diabetes and blood testing, which brought some £24 million worth of benefit to Unilever, and they didn't properly compensate him for it. He pursued his claim all the way through the courts and all the way up to the Supreme Court and won, and got an award of £2 million. What does this mean for employers? If you are employing people who are inventing items, creating something new, developing something, you need to look at this quite carefully. For many employers, they don't adequately compensate employees who come up with something that is a revolutionary item or something which is a real major development. If you're in that bracket of employer, look at the judgment very carefully, come and take some advice, and we can look to help you in how you compensate your employees for such an item. Next, I'm going to talk to you about an Italian case. I'm not going to pronounce the name because it's quite a difficult one to pronounce, but this is the Italian case which hit the press this month, about where an Italian solicitor said that he would never employ somebody who was gay. Now that was a discriminatory statement, and the regulatory authority or representative body for the LGBT community in Italy pursued a claim against him that that was dissuading lawyers from pursuing employment with him because of that case, and they won. Now what does this mean? I think it's pretty obvious that employers should not be making discriminatory statements in public. If you do, you're actually at risk of people pursuing claims against you as a consequence of that statement. So just simply don't do it. Finally, the case of Curless and Shell, which is about legally privileged communication. In this case, the courts again looked at the question of whether legal advice, which was potentially discriminatory in its nature, had to be disclosed. And what was found was effectively that common advice that is given is not disclosable. This is a good case for employers who take proper legal advice, who look to use their lawyers in the right way. However, legally privileged communication should not be a mask to potential discriminatory action either. It's a bit of a close balance, and it's something to look at very carefully. If you do need proper legal advice and you do have a situation which is causing you serious concern, Herrington Carmichael can assist you. We do benefit from legally privileged communication, and as always we'd be happy to assist you. That's it from me this month. I'll be back to you in December with our usual, slightly more Christmassy update. Thank you very much.